So is Wange not an institution?
It's an institution, but not an institution of government.
But is it not an institution where revenue, state revenue has been put in?
Yes, it may be, but it's not an
No, you cannot say maybe, Attorney General. Is Wange not an institution where state money has gone in? You cannot speak with a folk tongue. 1 minute you're saying government did the Reconstruction Act because it is state indebted and insolvent. This is your compelling reason. And now you want to run away from it. What was the compelling reason, Attorney General, for you to do the Reconstruction Act? Maybe let's go back.
No, the fact is, Chairman, that an institution may be indebted to government doesn't make it an agent of government.
Can you answer the question? What was the motivation of government to reconstruct Wange?
As I explained, the two requirements are outlined in Section 4 of the Reconstruction.
So you are not responding.
And that is the...
Attorney General, let's go together. Let's not, we are very clear. We have a role to play. And this is the Constitution which binds all of us. If members are following this, you are very clear in why government got involved. It was a state-indebted, insolvent company. That was the compelling reason. State-indebted, insolvent company. Then we come to 299, which talks about parliamentary oversight over state revenue. And revenue at any institution. Because you want to hide behind the fact that all agencies of government. But this does not, it talks about all agencies of government, and it also talks about institutions which are not run by government, but government has a stake through state revenue. And you're not responding to that.
I'm not sure how the Chairman wants me to respond. I think I've tried to make myself clear that as far as I am concerned, the agencies which are subject to parliamentary oversight are agencies of government. And there has to be very clear factors indicating why one would say that they're agencies of government. And in the case of companies which are put under reconstruction orders, the fact that they are indebted to the state does not make them necessarily government agencies. Government has to go further and ensure that it controls them for them to be government agencies. And then they are subject to parliamentary oversight.
But you're then contradicting yourself. Because government does not control Wange.
Yes.
It does not control Wange, and you're saying yes.
Yes.
So then, why did it go for Wange?
No, the Reconstruction Act applies across the board. It applies to entities that are not controlled by government as well.
But then it also talks about institutions. So what is an institution?
Yes, institutions of government.
No, it does not say institutions of government.
It says institutions and agencies of government.
No, it talks about all commissions and institutions and agencies.
Of government.
But commissions are not state-owned.
Well, as long as they're commissions, commissions are incorporated by statute.
So then, if you then say, let's go further. Is there follow-up on this matter?
Yes.
But Honorable
Chair, the very fact that the Attorney General is a lawyer of government, the very fact that Parliament is an arm of government, how does the Attorney General excuse us in a setup where government is involved and Parliament is an arm of government? The government has got three arms: the executive, the judiciary, and the legislature. And the Attorney General is a lawyer of government. This is why he has come here and is obliged to be here. Because he's a lawyer, he's our lawyer. He's a lawyer, he advises government. This is why laws pass through the Attorney General for advice before they even come to Parliament. And this is why the minister had to engage the lawyer of government. Because Wange has got interests of government. And under section 299, Parliament has the right to oversee expenditure by the state. And the state is comprised of the three arms which I alluded to, where Parliament is part of. Why then is the lawyer of government comfortable by working for government and not comfortable for Parliament to interact with the administrator working where there is an interest of government?
General, are you aware that the one get debt came through Papa Parliament?
It may have been authorized by government. I don't know. I haven't been given those facts. But Parliament, and certainly this committee, has every right to follow the debt through the Minister of Justice and through the Minister of Mines and call for explanations as to what is happening.
Thank you, thank you. Let's hold it there. The administrator is working on behalf of the Minister of Justice and Minister of Mines. So why are you not comfortable in allowing us to have access to the administrator?
Well, I didn't say you cannot have access to the administrator. All I am saying is that Wange as an institution is not a government-controlled entity or institution.
So
And that parliamentary oversight.
Attorney General, by virtue of invoking the Reconstruction Act, Wange now directly falls under the Minister of Justice. So therefore, where the minister is, Parliament goes.
Yes, that's why I'm saying this committee has every right to call the Minister of Mines, the Minister of Justice, to come and explain to this committee what is happening.
But you see, yes, sir.
Attorney General, so is it, can you put it on record that so you came all the way from your office, you tell Parliament that hands off one? Is it what you came all the way from?
No.
What is your advice to us in short?
Well, that's why I said I'm not giving advice to Parliament or to this committee. This committee is entitled to its own legal advice. Just to clarify.
This committee, sorry, as to what is your advice to us as a committee in short?
I think
Well, I think it's beyond my mandate to give you advice.
No, I think I told you. I think to just put it in a way which relates to what we're talking about is that we have the issue of the administrator who clearly has refused to be accounted. Okay. And the Reconstruction Act empowers the administrator. So it is the powers of the administrator. How far do they go? Is the law unto himself? He is appointed by the Minister of Justice. And by virtue of being appointed by the Minister of Justice, which is also another, that's another arm of the state, which is government, which is accountable to the Parliament. What do you make of that? Because my next question is that, okay, who does the administrator then account to?
The administrator, in terms of the Act, accounts to the Minister of Justice who appointed him. So, but in terms of the Act, he's not accountable to anyone else except the Minister.
But who is the Minister accountable to?
To Parliament. Right? Yes. But you see, you cannot do it by extension. To say because he's appointed by the Minister, therefore he's also accountable to Parliament.
But you're not understanding, Chief Justice. To be honest with you, sorry, Attorney General. Attorney General, I think we cannot play these games. There's certainly something which is a very clear. This is state revenue, first of all. We must agree. This is state revenue. And when it's state revenue, Parliament is an oversight over state revenue. And it is the same thing that no one, probably except the president, cannot be summoned by Parliament. If Parliament believes there's an interest, equally, and we now go to standing rule order, because I think we've done this one, let's go to the Green Book, which compels us to invite anybody who we think has something to say to the aspect of the inquiry. The inquiry is not only limited to government enterprises. Government has other players that engages And the inquiry goes as far as also inviting those players. This is about national interest, this is about accountability. So to us, we are really not understanding government's position, because if there's anything, it actually gives credence to the fact that this Reconstruction Act was not done in a manner which even the Attorney General understands. Because they're failing to really explain it.
Honorable Chair, thank you. Does this mean, Honorable Chair, that if the minister gives instruction to the administrator, he can actually hide behind the administrator, because we cannot interrogate the administrator because he's not accountable?
Can I also follow up on that?
Yes, Honorable.
Yes, Attorney General, if you believe there's a lacuna in the law, what would you have it read for you to really say now Parliament or this committee has power to summon whoever it requires, especially as it relates to this investigation? What is it that you think would be required to be included in the Constitution according to what you believe, so that it can either cover that lacuna, to read the way you want it to read for this committee to have the power you believe it has, which is not supported in the law? What would you want?
I think that's the question as we wind up. And I think just note it, that if there is a lacuna, but I don't think there is a lacuna, because this is state level, simple term, state level, and state revenue must be accounted for through Parliament oversight. And this is where you are not being clear to us, Attorney General, that what was the compelling reasons for the Reconstruction Act was because government has a stake in one. And it has already got a majority stake, but you still went on to reconstruct it. Okay. And reconstruct it, it was because of the money. State indebtedness. It doesn't even talk about it controlling a state, but because government is owed money by Wange, you felt that it was insolvent. And then you went to then reconstruct. Because the other question is, how many other companies are under that? I mean, we have to look at government expenditure in terms of all the state enterprises. There are shareholders who are not government, and government is not the sole shareholder, and you did not respond to that. And you cannot get away with it. And first of all, we must agree, step by step, does Wange owe government money?
Yes, it does, certainly, otherwise we would not have been put under an order of reconstruction.
And you believe that is state revenue?
Yes.
So, 299 talks about state revenue. And why are you not aligning yourself to 299?
Well, maybe let me try to explain myself in another way, Mr. Chairman. Parliament cannot exercise over a company like Wange any power that it would not otherwise have if it's not under an order of reconstruction, because it's a privately controlled company. It's got its shareholders and other people. So, Parliament, if there was no order of reconstruction, Parliament cannot itself exercise oversight over one.
No, we do. We do. Where there is money, even if it's 1 cent and it's from its taxpayers, we move in. It must be accounted for.
Well, if Parliament can trace that authority and power to the Constitution, then it's in order.
But because you're now confusing the whole thing, Attorney General. 1 minute you're saying Parliament has no power to trace Wange, the next minute government can take over Wange.
No, what I'm saying is the order of reconstruction itself does not make Wange an institution of government. And Parliament only exercises oversight over institutions.
But that's not, I think you're missing the point. World is not an institution of government. Government has invested in Wange.
Yes.
It is the revenue. And then don't take us round and round. We are following the money.
Yes, but the
Honorable
revenue.
members, the issue is the revenue. The money government is putting into Wange, and that's our interest.
Yes, I completely understand that. That is why the minister is following up on it. And that is why he issued the order. The minister is following that money in a privately controlled company.
Honorable Chair. For Wange, even without invoking the Reconstruction Act, even before that, Parliament would have the right and mandate to follow public funds. Why? Because Wange as an entity has received advance payment from ZPC. That's public funds, and we have a right to follow those funds, even if it were a cent. And I'm coming back to this. I'm not sure if, before advising the minister to invoke the Reconstruction Act, you really were furnished with total and complete documents to enable you to consider whether it's viable to put this company under reconstruction. Because from what you are saying, I see clearly that you are not aware that ZPC was advancing money to Wange, notwithstanding the fact that there are other shareholders. That's government money on its own.
Well, I was aware that Wange is indebted to government and other state institutions to an amount of approximately $118 million. That I was aware.
And are you aware that debt was converted into a loan that is payable in 15 years' time?
Well, I'm aware that it was converted into debentures. And debentures are just loans.
Payable in 15 years' time.
Yes, under a scheme of arrangement. And I understand that the scheme of arrangement was not followed through. And that was why the minister then deemed it fit that action must be taken, or else Wange should be placed under judicial management in terms of the company's act.
Did you consult other players? And because what I want to also understand from you is that where does it leave Wange? Is the public company, is the private company now under the reconstruction? Because there are certain shareholders who have their rights. And their rights in terms of the Companies Act. Well, can you talk to us about that?
Yes, Wange is still a private company. We still got those shareholders. Nothing has changed except that the authority and powers of the shareholders are now vested in the administrator for the time being. That is what the Act seeks to achieve. But they are still there. It is still a private company.
But the shareholders, honestly, if you really look at it, Zimbabwe is open for business. That's why we need clarity on this. That anybody who registers a company in this country becomes a shareholder. They can just wake up tomorrow and the company is under reconstruction. And that's what we are saying.
This is an act which is in our statute books and which is available to any investor to be to peruse or to be advised of, and investors make their investment subject to the laws of the country.
Okay, just before, but Section 71 talks about property rights. Property rights, 71, and people with property rights. Have you not violated this supreme section of the Constitution?
No, Mr. Chairman, no person has been divested of his property by virtue of the order of reconstruction.
Attorney General, if you look at precedents and previous conduct of government in respect to companies that have been placed under reconstruction, the culture or practice is that immediately with absolutely no explanation, those companies end up belonging to government. I want to give you a practical example. When we were in Bunawa a week ago, the Minister of Finance listed about 17 companies that were subject to privatization. And amongst those were 2 companies that I clearly know belong to SMM, and these are up for privatization under ZMDC. So for me as a member of parliament, the assumption is once under reconstruction, a company therefore belongs to government at the end of the day, and government can do as it pleases. But attached to this, my commentary, and perhaps part for the last answer that will attach to Nduna's question, my question to you is, you advise the minister, do you really think this is good law, particularly in respect to our going mantra that Zimbabwe is open for business? And should this piece of legislation really exist outside the ambit of the Companies Act? You may want to save this one for the end.
I think Honorable Nduna, this question, you might as well also respond.
Can I just maybe add on to that, Honorable Chair? Honorable Chair, I also want the Attorney General to tell us what he reads Section 117 to Section 119 of the Constitution that gives us our mandate, that is the oversight, the legislative and the representative role. How he interprets that to me in terms of our interrogation in our quest to carry out our mandate as parliamentarians, not only as a committee of parliament, but as parliamentarians, our 3 roles in one. How you see us fitting into those 3 roles without interrogating the manner in which other institutions that are outside government institutions carry out their work.
So I'm not too sure I get your question. Please, could you rephrase?
We have 3 roles: the legislative, the oversight to interrogate the manner the executive carries out its mandate, and the representative role from where we come from, of over 50,000 people on each member of parliament, the 210 of us, plus the 60 representatives, the proportional representatives. What do you read that to mean, the 3 roles in one, as it relates to the way we carry out our mandate? Because I see you restricting parliament to carrying out oversight only on government related institutions. But we are not only on that line of thinking or on that line of mandate. We have 3 roles in one. I ask for you to define what it means as it relates to those 3 roles.
Perhaps I'll reiterate what I said earlier, that Parliament can only carry out its oversight role in terms of the mandate is granted in the Constitution. And you asked earlier whether there is a lacuna in the Constitution which then stops Parliament pursuing wherever government revenue is gone, notwithstanding that is not a government controlled entity. And my response to that would be that in Section 299 of the Constitution, an additional power would have to be inserted to give Parliament the right to follow government revenues wherever they've been invested or expended, notwithstanding that the institution or agency is not controlled by government. That would have to be a specific power to be inserted into Section 299 of the Constitution. That is my view. I'm not advising Parliament, neither at this stage am I even advising the executive on it.
But Attorney General, you're the same Attorney General who recommends the President to appoint 9 ministers in cabinet instead of 5.
I did not advise him.
So then how can the President make such a decision?
No, I only advise where my advice is sought.
No, but you're the Attorney General,
yes.
And you're there to advise the President on the legal issues. They think President made it boom by appointing 9 ministers in terms of 5. And where were you? Where were you in terms of giving that legal advice?
Mr. Chairman, when a lawyer advises a client, it's up to the client to do what they want.
So you're telling me that the President disregarded your advice?
I'm not speaking for him. You may ask the President.
Honorable Mure, and then Honorable Batamana.
Okay, thank you very much, Mr. Chairman. I just want to pose Mr. Attorney General, are you aware of the activities which is being done in Rwanda? I mean, things like rampant corruption and looting which is going on in Rwanda. Before I proceed.
No, I am not.
You are not.
I've been given, maybe if I may just explain further, I've been given certain information which is to the effect that there's been mismanagement at Wange, and that therefore an inquiry is necessary, and that is why the order of reconstruction was then passed on Wange. That enables a proper investigation to be carried out through an administrator who will then report back to the Minister of Justice with these conclusions.
Okay, Honorable Batamana.
Thank you, Chair. Attorney General, sezvomutemo uchitaura unotitendera isusu pasubsection 299 kuti at every level Parliament inofana kuenda as long paine mari yehurumende kambani iyoyo. Inini kuti wozoona kuti pane mutemo kuti unodzivisa secretly wamunozira imi micheto musikazikanwa vamwe vese, asi urimo muconstitution wokuti unozodhingidza zvinhu kana zvinhu zvavada kunakugadziswa zvofirizwa kana munhu ane mainterest akauzviita like this. Iwo mutemo wamazoverenga maverenga zvakanaka kuti matipa masimba robva matitorera kuti munotigaidha kuti tirambe timirire muno zvakanaka naro ndemumirira hurumende napresident vasasekwa kana kuti vasashoka kana kuti nyika isaparara kana makuti imini pane mutemo uyu wamazotoro kuti isusu hatina simba wakanyorwa nevanhu vese sokunyirwa kwaitwa neconstitution ichitendera nyika yese. I doubt very much because I think wakaiswa nevanhu vekuru vakavakuziva kuti tinoziva kana zvakudai tinovakavhara zvakanaka nokuti panapa hapasina chokwadi because mutemo uri kutaura zviri pachena unokuti pasimba taita kuita anovharwa panze taita mastupid nyika yese yazvoona touya kana taudza kuti makaendeko kubairo but yeti mutemo ndiwakatekisa ikoko makuuta husimo. Saka izvozvo imimi kana muri society imi maiona mutemo wakadai uyu makausiya sei uchiexista uchiramba wakadai munakuugadzirima usakaita kuwandu titange mabhisa apa zvinokubharika taikuzaita ikoko zvinopedza zvadzora zvino zvawaisa mari yegavhumenti akakwira ndege tikaenda kuti kati mari yehurumende yekoparara zvakangofanana nezvakaifambira iko zvaiparara. Saka imimi wai makauregera mutemo uyu uripo pasaidi wakanyarara uri saine nhasi nomakukuti
Mhinduro yangu ndingangoti ini ndiri Attorney General handiziri ndinoita mutemo.
But you are sounding to be part of the problem.
No, honorable members, I think that's something that we can deliberate amongst ourselves. We will deliberate with that. Honorable Choma, we need to conclude.
Okay, thank you, Chair. You mentioned that, I just want you to make clarity. There was a court order that gave birth to the scheme of arrangement. and you put in the Reconstruction Act. There I wanted clarification which the act supersedes the court order. Number two, you mentioned that one of the compelling pushes that made you go and to implement the Reconstruction Act, that there was rampant mismanagement, and hence the reconstruction will give you ample time to get into an inquiry. Are you aware that there was a forensic audit ongoing that had been instituted by the board of directors there, and the report was due to come out in January?
Attorney General, just on supplementary, are you aware that the scheme of arrangement was before the High Court? And can the Reconstruction Act override the High Court?
A scheme of arrangement is an order which is obtained by parties who approach the High Court and say, can you please give us this order? That is the order they obtain. And that order is granted on the understanding that the parties will abide by it, particularly the debtor. If the debtor fails to abide by the scheme of arrangement, then depending on the terms of the order may cease to be in existence because it's been breached. So the issue of whether or not the Reconstruction Act supersedes it is really neither here nor there. The thing is that the Reconstruction Act is an act of parliament, and it sets out what the law is. If a company is indebted to the state and it's insolvent, then it can be placed under a reconstruction order, regardless of any other factors.
Okay, I think we have Honorable Chairman Honorable Gebus, okay, Honorable Chombo, the President.
Well, it wasn't answered. Were you aware that there was a forensic audit going on which was supposed to give a report back in January?
Yes, from the papers I got, there was mention of a forensic audit which was going on, but the forensic audit itself cannot stop, like I have said, an act of parliament being implemented.
Mr. Chairman, is the Attorney General confirming that he received confirmation from the data that there was a breach in terms of the High Court order for the scheme of arrangements?
No, I did not receive any confirmation from anybody. I acted on the information that was provided to my office by the Minister of Justice, which had obtained from the Minister of Mines. That is the information I acted.
But you know, Attorney General, what the member is trying to get to is that you're supposed to consult us so that you get this information. And while the Reconstruction Act also gives the power to the minister to reconstruct and then us later, that whole process has not been done of finding out from the stakeholders, from the shareholders, what is it. And you are getting information without also having to get more information from other stakeholders. What are you doing to ensure that you think fulfill that?
The information I got was that it was urgent to place the company under an order of reconstruction, and that it was also urgent to do so before other creditors applied to the High Court to place the company under judicial management. So on the strength of that, I did advise that the company could be placed under an order of reconstruction, and that any consultations which were necessary under the Act would be done afterwards.
When one of the board members, Mr. Tome, I hope he's here, was under oath, he said while following up on the process of on trying to inquire the paperwork which had been sent to the Attorney General,